Hello, Your Honor. 𝗵𝗵𝗡 on behalf of Aidan Kearney. Good to be with you. To my left is my client, Aidan Kearney.
And Your Honor, Mark Better on the state on behalf of Mr. Kearney.
Sure. And there's another attorney on Zoom as well? Okay. All right. So,
Good afternoon, Your Honor. Attorney 𝗕𝗏𝗄𝗏.
good afternoon. So there are a couple of motions that have been filed and other matters. Before we get into those, can I see counsel at sidebar?
Hi, Mr. Kearney. Hi, Mr. Bradel.
Hello, Your Honor.
All right. What's the first order of business, Mr. Cosgrove? I'll start with you. I see counsel from New York is on as well.
Yes,
Mr.
Mark
Better,
Better, Mr. Kearney. How are you, Judge?
Good.
Nice to see you.
Okay. What's the first order of business, Mr. Cosgrove?
Your Honor, I think the first order of business, I would at least like to take up the issue that has been hanging for quite a while regarding the search of the seized devices and the memorandum that I filed in response to your Honor's order last time in opposition to what I understand to be the defendant's motion to screen other things besides attorney-client privilege, specifically reporter privilege.
Okay.
And I'm, as I was leaving for court this morning, I received a text from Mr. Kearney indicating that he intended to rely for his filing on something previously filed. I unfortunately did not have that with me and have not been able to look at it, but as far as the argument itself goes, I'm more than willing to rest on my filing for the most part, particularly if Mr. Kearney is as well. I'm sure I reviewed that other document at some point, although it's not fresh in my mind.
Okay. So what you're referring to is that there is a taint team that's in place.
There is a taint team in place.
That's Judge Macy, right?
That's Judge Macy is the evaluator, so to speak, of
Yeah.
privileged material, what should be turned over and what should not. And Mr. Verino is the electronics expert that would
Okay.
actually do the search.
Yeah.
And my problem, Your Honor, is that they fulfilled their part as far as they could by returning within, I think, a week of Judge Krupp issuing the order, their acceptance of the order and the responsibility to undertake that. And as far as I know, the court has not forwarded to them the appropriate search terms. I don't know what search terms Mr. Bradel supplied or what they...
Let me just ask Mr. Bradel. Mr. Bradel, did you supply search terms?
I did, Your Honor. Document 67, I believe.
Number 67. Okay. Have you seen that, Mr. Cosgrove, or is that something that's outside your view?
Well, Mr. Bradel had permission to file them ex parte, so to speak, if he believed that they might disclose something inappropriate to the Commonwealth.
So you want me to forward that to Judge Macy, to Mr. Verino?
Well, I don't know that I do, Your Honor, because I want you to make an evaluation first of the appropriateness of those terms, which the court is supposed to do under Judge Krupp's order.
Okay. I'll take that. I'll do that myself.
All right. I appreciate that, and I would say if the court wishes to hear further argument, at this point, I would say just forward it all to Mr. Verino, tell him there may be further instructions coming from the court,
Okay,
because it's been, what, 4 months now?
okay. Let me, I'll do that. I'll forward it. Okay, I'll take a look at what Mr. Bradel has requested. If it's appropriate, I'll do as you request, okay?
All right, thank you.
Mr. Bradel, anything you want to say on that?
Yes, thank you very much, Your Honor. So, Judge, in document 67, it was just the original filing on this very issue where I asked for this hearing. And so in that case, Judge, there's a 1985 case, which I would kind of call it, it's kind of a long, convoluted name. I would just call it the Petition for Protection of Confidential News Sources. It's from 1985, and it's still good law, and it addresses the situation that there's no statutory journalist privilege in Massachusetts, and it says that courts should deal with it on a case-by-case basis, as we are here, of course, and address issues as they come up. And just a quick quote up from the case, Judge, is that this court should consider alternative remedies for compelled disclosure of journalist source material. And my client has informed me, and he has previously sworn in an affidavit in this case, that his phones contain journalist source material. All this wide swath of electronics that the government has seized in this case, that there are areas where there are journalist sources. And most alarming, most eyebrow-raising, Your Honor, is that there are some instances where there are sources giving information on these very same state police actors in this case that we have been criticizing and pointing out errors and alleged corruption on. These people are the ones that are going to get this information. It's not even like the FBI or a third party. This is source material on the people that Mr. Kearney has been criticizing in the Karen Reed case. So I can't think of a more important case where a court ought to craft an alternative remedy for compelled disclosure than this. We have these conflicted officers who have, we contend, perverted the witness intimidation statute for their own goals, and now they possess my client's electronics, and they're going to go through them for source material on their own wrongdoing, their own misdeeds. It's unbelievable. It's like a John Grisham novel, Your Honor. So this court is in a position to say, time out, under the Petition for Protection of Confidential Sources, I can craft a remedy here. In fact, I think it's the court's duty under the First Amendment in Article 16 to craft a remedy and say, time out, the taint team is going to be sworn in under oath. They're going to provide information relative to the search warrant, relative to the court orders, but they may not provide any journalist source material, in this case, to the Commonwealth. And if there is an issue with any such material, it will be isolated off to the side. The court can look at it in camera, along with the defense, sort of like a Lumen Martin type situation, Your Honor, and we can take it from there. That would be my request on that, and I think under that case, that would be the appropriate remedy for the court to address here.
Okay.
Thank you. That's all. Thank you.
Yeah, I get it. All right. Yeah, no, go ahead. Go ahead.
First of all, I heard Mr. Bradel say that Mr. Kearney has produced an affidavit claiming that journalist sources are contained within these electronic devices. I don't claim to never miss something, Your Honor, but I don't think I've seen it. So I would ask for some specification of where.
Yeah, Mr. Bradel, is that part of in-camera Exhibit A?
Judge, I can't tell you off the top of my head. I want to say it's probably 30 or 40 documents ago, but I'm happy to get it to everyone when I can get to my files.
Okay, that's fine. Why don't you do that? Why don't you send a copy to Mr. Cosgrove and send a copy to Attorney Sandel?
The second thing I would say, Your Honor, is that, and I'm not necessarily opposed on principle to making new law, but I think I'm correct in saying that if the court rules that the taint team screens for anything other than attorney-client privilege, it would be the first case I am aware of in the United States that has ever had that holding. And I think it would also be the first case where the so-called qualified journalist privilege has not yielded to the demands of and the interests of the government in terms of vindicating search warrants and criminal laws. And finally, if I could, Your Honor,
No, go right ahead.
Judge Krepp's order also set a time, I believe, for Mr. Kearney to provide the Commonwealth with the passwords to these electronic devices. And I don't know whether there's been a formal answer on the record to that.
Let me ask Mr. Bradle. Do you have a response to that? About Judge Krepp's order?
About the password, Your Honor? I'm sorry.
Do you know what paper that was, Mr. Cosgrove?
I'm afraid I don't off the top of my head.
All right. So what you're saying is that there's an order from Judge Krepp that orders Mr. Kearney to provide the password to the device?
Yes, it's set out in the procedure
Okay.
of Judge Krepp's order.
All right.
And you know, I don't know if well, let's put it this way: if Mr. Kearney has already provided that to the court, we need it, or rather, Mr. Verino needs it in order to feasibly open the devices. If Mr. Kearney is contending that he's forgotten the passwords, you know, we need to know that so that Mr. Verino can proceed under what measures he can to crack the devices without the password. Or if Mr. Kearney is maintaining that he has a Fifth Amendment privilege against disclosing the password, then I think still I would tell Mr. Verino, or ask the court to tell Mr. Verino, that he may proceed. Well, proceedings are underway here, but I would then file a motion to have the court adjudicate whether he in fact has such a Fifth Amendment privilege.
Okay. Mr. Bradle?
Yes, thank you, Your Honor. So at this time, we're not pressing any Fifth Amendment issue. My remembrance of the case law on that is not, it's not particularly solicitous.
No, I agree. Yeah, I think that there's a case on point from the SJC.
Right. But, Your Honor, some of those devices are pretty old, and some of them are old and not Mr. Kearney's. So there's some issues there. What I would suggest on that is that if there is, I happen to know that the state police do have at least one, if not two, of the passwords of the devices that I think they're primarily interested in. And my thought is that they can report back if they have any issues, and we can take it from there.
Okay.
Is that all right?
That's not the order. The order is that he's to turn over the passwords.
Right. Mr. Bradle, have you responded to that in any way? Have the passwords been turned over? Is there?
Judge, I think that
I mean, if I don't, obviously, as you both know, I've come into this afternoon after one of my colleagues has been recused. So I'm trying to just kind of narrow the issue here a little bit.
Sure, Judge, we're not opposed to doing that. My thought was that we were resolving this stuff, and then once the court was given the green light to the taint team, we'd be happy to do whatever the order said.
All right. Okay, I get it.
I just was sort of chronologically looking at it as this was the next thing, and then we'll be happy to comply with whatever the order is.
Well, you already got an order from Judge Krebs, so what I would suggest is I'll give you 10 days to compile that, okay?
Okay, thank you.
All right. Next thing, Mr.
And,
Cosgrove.
I am agnostic, Your Honor, as to whether I will yield to Mr. Bradle's preference as to whether he wants to go forward on my bail revocation motion or whether he wishes to press his discovery motion at this time.
Okay.
Judge, I'd like to be heard on the motion to compel, if I may.
Okay. The motion to compel. Go right ahead, Mr. Bradley.
Thank you, Judge. I'm not going to belabor, I'm not going to just repeat the written filing, Judge, but, you know, it's been a long time. There's been many discovery orders in the case. One comes to mind May 8th from Judge 𝗕𝗄𝗄𝗃 of last year, and still here we are. And there's also, if I may, Judge, there's some qualitative issues that we have as well. We've gotten screenshots of text messages, very important text messages, and that is just not an adequate measure of compliance with providing text messages, Your Honor, because we don't have the whole string, we don't have the metadata, and something that just occurred in the Karen Reed case the other day, excuse me, was that a witness named Kerry Roberts took screenshots of her text messages that were provided to the defense as screenshots. Here, same exact situation as we are here. And did not, in my opinion, give good faith answers to foundational questions about whether they were her text messages. And these text messages were not admitted. So here we are. And that's a perfect example of why screenshots of text messages sorry, are not something that ought to be satisfactory. So we need the digital copies of these items. They're ordered, they're supposed to be given, and these sort of piecemeal pieces of paper with no foundational support, no assurance that it's the entire string, and they're really not the entire string. These really need to be given to the defense as a matter of due process, Your Honor. And I can say the cases, but you know them.
Okay, let me hear from Mr. Cosgrove on that.
Before I get to that, Your Honor,
Go ahead.
I would like to address a few things. Specifically, I would like to start with the affidavit that has been submitted in support of the motion.
Okay.
Has Your Honor had an opportunity to review that?
Which paper is it? There you go. Let me see. Yeah.
Well, let me see if I have an extra
Oh, yeah.
copy.
Okay. I'm familiar with that.
Thank you. I know Your Honor looked at it and entered a preliminary order
Yeah.
allowing the motion for impoundment pending today's proceedings. And I want to place the court on notice that I object largely to the order of impoundment. I don't object the impoundment of the name of the witness in item number 8, who is allegedly described with an obscenity, although that is the least of the characterizations of his behavior, allegedly described that way by Ms. Peter. But I do object to the affidavit being supported by what in effect, for the record, would be an anonymous affiant. I particularly object to that because before the ink was dry, Mr. Kearney essentially outed the name of the affiant of his own YouTube presentation, and her identity was discerned by Ms. Peter the same day, and was the subject of an extensive post on YouTube. So there is no purpose at this point, Your Honor, to allowing her to pretend to hide behind an impoundment.
Okay, I got it.
Moving on to that, Your Honor. I object to the affidavit. I think that Mr. Kearney should produce the affiant, or that the affidavit should be stricken. This affidavit largely recounts purported hearsay by Ms. Peter, and I'm not going to go through them all one by one, but I will say, for example, that the assertions set forward in the affidavit are so preposterous and outlandish on their face that I really, I don't mean to be overly critical of brother counsel, but I really question the judgment of counsel for Mr. Kearney in going forward and filing. For example, if Your Honor will look at item 6, supposedly Ms. Peter said, and the affiant repeats it as gospel, that at one point in the jury deliberations, Ms. Peter met with a prosecutor for lunch, and that during the lunch meeting, doesn't say where, it doesn't say when, during the lunch meeting, the prosecutor was indiscreet enough to tell Ms. Peter that he knows the foreperson, who is a retired police officer, and he, the juror, is guaranteeing a mistrial. Now, does that make sense to you, Your Honor, that an experienced prosecutor, and I don't know if the named prosecutor has appeared in front of you or not, or has an impression of you have an impression of his ethical qualities, but he would have to be both unethical and stupid to both engage in this kind of jury tampering, and there's nothing else you can call it, and essentially contacting a juror to fix the outcome of the jury trial, and then turn that information over to a woman who is a known YouTube blogger. That's one. In item 7, she indicates that she, Ms. Peter, is paid $1,500 each month via CashApp for her assistance in the Karen Reed and Aidan Kearney prosecutions. Well, I'm tempted to make light of this, Your Honor, and say that if the district attorney is paying Ms. Peter that money, he's not getting his money's worth, because I haven't heard from Ms. Peter in the entire time that I've been representing the Commonwealth in this case. But put that aside, CashApp has records, as I understand it. It has records from what bank account to what bank account. I don't know what Mr. Brado did to verify this, but I don't see any records from CashApp, and I would like to examine this call Antonio, excuse me, so far it's still in the pound, but I guess I forget about the 9 million person to let the man
That's
the
the pound,
cat out of
so I
bed.
object, and I move that it be stricken.
Okay. Go ahead, Mr. Vice.
I would like to examine the affiant as to that information and what, if anything, that she did to verify. The affiant then says that she personally has heard Ms. Peter on the phone with Hank Brennan, that she personally recognized Hank Brennan's voice, Peter told him that her people leaked it to the media, referring to the federal investigation being over. I think the people who, putting aside the fact that I think the person who leaked it to the media effectively was the U.S. attorney in a radio interview who responded to the question of whether she had communicated with the Commonwealth and the police department as to the progress of that investigation by saying that she couldn't verify whether a grand jury investigation was over, but that it would not be uncommon for her office to communicate with law enforcement, et cetera, et cetera. Anyone who had any sophistication knew what she was saying, and about a week later, the district attorney's office verified in open court that that was the case. So I don't know why we needed Ms. Peter to leak that to the media when we were announcing it in open court. But at any rate, it's in there. I would like to examine the affiance as to how she knows Mr. Brennan's voice, how she knows about these multiple conversations, when they took place. And finally, I'll skip over the rest of them for the most part, but I come to items 14 and 15, in which Ms. Peter informs her that Jennifer McCabe bought her a brand new sectional, I assume she's referring to a sofa, as compensation for her assistance. I'm not quite sure how Ms. Peter has assisted witness Jennifer McCabe, but maybe it's revealed in the next section where Section 17, where Peter informs her that Jennifer McCabe paid her for her show of support. Well, subsequently know that apparently the affiant lives in the same apartment building of Ms. Peter, who has not denied in her own posting that she knows this particular witness. And presumably she knew that Ms. Peter had a brand new sectional. I suggest that the information that Jennifer McCabe brought her a brand new sectional is made up out of whole cloth. And I'm not going to go through it all because I'm hoping the court will give me an opportunity to examine this witness on the witness stand. But I think the court could ask itself why this particular affidavit is being submitted now in support of what I would suggest would otherwise be a fairly routine thing that comes before judges, motions to compel discovery.
Okay. Let me hear from Mr.
And
Oh, yeah,
may
no,
I-
I'm sorry. Let me cut you off.
And I suggest that the reason is this, and the court can make its own judgment. And my assessment is that the purpose of the motion is to dirty Jennifer McCabe. I don't think it's an accident that Jennifer McCabe was testifying today in the other courtroom and yesterday in the other courtroom. And I suggest that the purpose of this motion, which has been loudly trumpeted by Mr. Kearney on his YouTube show, was to accomplish his oft-stated purpose of prejudicing the jury in that trial.
Let me just talk to the attorneys exactly on that. Mr. 𝗏𝗏, the floor is yours.
I will stop at this point unless you
Okay.
has questions.
That's fine. All right, Mr. Bradel.
Thank you, Judge. So, Judge, a lot to respond to. First of all,
Why was that affidavit attached to the motion to compel?
because, Your Honor, that's the basis to show that this information exists. The Commonwealth has not provided any of those things related to 𝗕𝗏. And my colleague, Mr. 𝗏𝗏, who I know is watching here from New York, he wrote a letter to counsel for the Commonwealth in, I want to say, October of 24. That was the first of his 3 letters that he wrote, pointing out all kinds of these things. Ms. Peter has been under oath at other hearings, my client's restraining order hearings against her, where she has said under oath that she's cooperating with the Commonwealth. She has said it many times online that she's cooperating with the Commonwealth. To this day, our 3rd motion to compel, discovery orders, the discovery was due a year ago, Judge, and we still have nothing. And so this woman came to us, Judge, April 21, Patriots Day, came to us Monday, April 21, and we did what a lawyer needs to do in that situation, which is we memorialized it, she signed an affidavit, and we submitted it as further proof upon Mr. 𝗏𝗏's letter that this information exists. And now we have it from the horse's mouth, Your Honor. So that's the answer to your question. This woman is saying to the affiant that she is working with the Commonwealth, giving all these details about making money, about meeting with these people, about receiving funds. A lot of this has been corroborated by other people on the internet as well, Your Honor, which we're in the process of gathering up. But this affidavit, Judge, was submitted for Mr. Kearney. It's got nothing to do with the Reed case. It has information in it that's important to the Reed case. We are not the Reed case. I am here today defending Mr. Kearney from these scandalous allegations that just absolutely seek to destroy the First Amendment in Article 16.
Okay, so what's the discovery that you want compelled?
So, Judge, I want all the information from this affidavit and from our motion to compel about 𝗕𝗏. She's a government agent. If this is all true, Your Honor, the DA's office is paying a third-party witness to intimidate witnesses in the Karen Reed and Aidan Kearney case.
So what? Maybe we should hold a hearing on that. Okay. So I'll take this under advisement.
Thank you, Your Honor.
I'll come up with an order as to how we should proceed on that.
Thank you.
Now, as to Mr. 𝗏𝗏, are there any other issues that you see? Any other motions that you want to bring to my attention? I know that I received a thumb drive earlier today that I've had a chance to review, and I'm sure Mr. 𝗏𝗏 has a copy of that.
Yes, I provided Mr. 𝗏𝗏 with a copy when I saw him earlier this morning. I don't know that he's seen it. I would like to play it for the court if I could.
Yeah, no, you can play it. So, Mr. 𝗏𝗏, this is Mr. 𝗏𝗏's motion to have your client's bail revoked, I guess.
Yes, Judge.
Okay.
If I may, Judge?
Well, I'm going to start with Mr. 𝗏𝗏,
Oh, sir.
then I'll go over to you.
Thank you.
Go ahead.
As Your Honor may know, I'm pretty much a computer illiterate, unfortunately. Everything is information telling me.
Mr. 𝗏𝗏, you want to come up?
Sure.
Yeah, I was on, who is that? Tell me who Guarino is.
He's a trooper in the Karen Reed case, and he's an electronics expert that's did the analysis of the 2 devices of Mr. Kearney's that were already searched, and that aren't really the subject of this whole tainting thing, and also did the analysis in the other case that he mentioned and has been defamed as supposedly missing all kinds of communications, which is not true. He was, as is alluded to, in an unfortunate car accident that you hear Mr. Kearney taking pleasure in. So, let me start with a couple of things, Your Honor, if I could just have a moment.
Yep, take your time.
Having had to put this together at the last minute because the presentation just came to my attention the other day, I didn't have directly in front of me the orders that Your Honor entered, although I think I summarized them correctly in my memorandum. But as I understand it, according to the docket, on March 5th of this year, after I initially brought this to Your Honor's attention, the docket entry records that the court orders defendant to have no contact, direct or indirect, through third parties with any of the witnesses or victims in this case, and 2, stay 100 yards away from any victim's residence or place of work. Defendant to sense bail warning read. Now, as I recall, that was sort of a provisional order, and at that time, even more so than today, I had just got the information relative to Mr. Kearney's antics outside D&E Pizza in Canton. Mr. Bradel hadn't really had time to absorb it. I didn't have police reports to give him. So Your Honor may remember that you put it over to the following day for hearing. After hearing that day, the docket reads as follows: additional conditions of release. 1, stay away. No contact, direct or indirect, with the named witnesses in his Superior Court cases. 2, stay 100 yards away from D&E Pizza in Canton, Mass. 3, behave in an appropriate manner while in any courthouse or within 300 feet of the building. Defendant to sense bail warning read. So with that clarification, Your Honor, I'd like to begin. We indicted Mr. Kearney because, in our view, he was engaged in a campaign of intimidating the witnesses. After we indicted him, one of those methods he essentially ceased, and that was leading parades of automobiles outside witnesses' homes and places of business. But he did not otherwise decease. So what we have here, Your Honor, is the most extreme recent example of Mr. Kearney's behavior. And if I wanted to bring these to the court's attention, I could probably do it about 4 times a week. But just to give you some other examples, if I might, of Mr. Kearney's latest hits.
Go right ahead.
Within a week or 2 of the last time I brought his behavior to your attention, he was on a live broadcast mocking Elizabeth Proctor, a witness in the Reed case, for thinking she was blue, unquote, or a member of a blue family, because family members were police officers, and because she gave oral sex to her husband, who was a police officer. And he went on in the oral sex thing for some time. One can imagine the effect that that has on a witness, knowing that she's being humiliated in front of hundreds, perhaps thousands of people.
Objection, Your Honor. This has been dealt with by the court.
He's given me some history, so it's overruled. I'll listen to your recitation.
I informed the court the last time, and the court viewed it, of his show-up and antics before the Albert's Pizza Shop. I have personally routinely heard him refer to the presiding justice online of the retrial as a cunt. He engages in constant defamation, for example, of Jennifer McCabe as a murderer, and he has described the others as murderers. And in general, he is aware and has remarked, I think this is another thing I brought to Your Honor's attention the last time, has remarked with satisfaction that the results of his broadcasts have made it difficult for these people to go out in public without being harassed and without being mocked. I would suggest that Mr. Kearney wanted this communication to be conveyed to Lieutenant Tully, knew to almost a certainty that Lieutenant Tully would see it, wishing death in the most horrible fashion to him and his wife, and knew that that would excite others of Mr. Kearney's followers to pile on, so to speak. I'd like to introduce an exhibit, Your Honor. I provided a copy to Mr. Bradel. I'll give him an opportunity to object, but I would suggest it could be marked for identification.
Yeah, we'll mark it for identification.
And,
you could just give it to
Mr. Bradel wants to object.
Okay.
I do object, Judge, based on relevance, materiality, foundation.
Would you give this one? Okay.
Thank you.
All right.
And just so we're clear, Judge, I don't even think the Commonwealth is suggesting this has anything to do with Mr. Kearney sending that. Which, of course, he did not.
Well, I'm happy to agree with what Mr.
We'll
Bradel,
mark it for ID.
with what Mr. Bradel just said, Your Honor.
Okay.
But it is always Mr. Kearney's response that when these witnesses are deluged with harassment immediately following his broadcast and thereafter, that, oh, of course, he had nothing to do with it. He didn't send it. But he knows what happens. And I would suggest to you, Your Honor, that this is relevant, not because Mr. Kearney sent it, but one, because the court could conclude that it was a logical outcome of the kind of scorn and hatred poured out upon Lieutenant Tully and his family. And two, that Mr. Tully, Lieutenant Tully, who is well familiar with these reactions, upon reading or listening to or being informed of Mr. Kearney's broadcast, could reasonably fear reactions from these sort of nuts directed at his wife and family. And I suggest that his reasonable fear is evidence of intimidation of the witness. And on that basis, Your Honor, I would ask that it be marked as an exhibit.
Yeah, we'll mark the disc as the next exhibit.
And I would further ask that it be impounded, because I don't want the comments made in that out there to give any other.
Yeah, I'll impound it. Margaret, here's the disc. Yeah. Yeah.
So I don't want to belabor this, Your Honor.
Can I just go back to Attorney Cosgrove?
Yes.
As to Exhibit A, could you explain that to me a little bit more?
One you just marked?
This one right here.
Yes. At about whatever time is indicated on the top of the email, I received that email from Lieutenant Tully indicating that he had received that communication from this person so far as I know, is unknown to all of us. Whether his identification is genuine or pseudonymous, I have no knowledge, and that he received it through LinkedIn. And that's about all the background that I can give you.
To your knowledge, though, this has, well, strike that. What's the
To my
relationship
knowledge, I
to
do
this
not
and
allege that
Mr.
Mr.
Kearney?
Kearney personally sent it.
Okay. I guess that's what I'm asking.
I allege, number one, that it may well be, one could infer reasonably that it is the result of Mr. Kearney's broadcast.
Okay,
That provoked
I get
it.
you.
And two, I infer that, one could infer that Lieutenant Tully reasonably anticipated these kinds of responses. You know, I don't know if this nut is going to be motivated to go out and try to assist in a car accident or in burning things down. And, you know, when somebody says to an audience that Jesus told him, Jesus wants revenge, how does that play? And revenge in the form of somebody being burnt up in the most painful way. You know, Mr. Kearney expresses concern that I gather what Lieutenant Tully is supposed to have done to his children is arrest Mr. Kearney on one occasion pursuant to a warrant at the bus stop after Mr. Kearney brought his children off. If Mr. Bradel had looked at the discovery that the Commonwealth turned over of the body cameras of the arrest, he would observe the officers carefully waited for the children to get on the bus and be on their way before their father was arrested. But yet, this is continually held out as a crime, while at the same time, Mr. Kearney has no compunction about wishing death on Lieutenant Tully's children and wife. So, Your Honor, I make those two arguments. One, this was posted with a sure and certain knowledge and intent that it comes to Lieutenant Tully's attention, which in fact has happened. And two, I make the point that a no contact order means no contact. The content, before Your Honor hears the First Amendment argument, the content of the contact is irrelevant as far as whether there was a violation of the order. And I'd just like to call Your Honor's attention, if I can do it, to a case that I cited in my memorandum to Your Honor. I believe I cited it for another purpose, but it's O'Brien versus 𝗵𝗏 at 461 Mass 14. In the course of that case, the court refers to the 𝗄 case on page 424 of the opinion, and it summarizes that case as follows. The defendant produced flyers with the word missing printed in large type across the top, between which was a photograph of a former girlfriend who had broken up with him, and offensive sexual remarks about her, and he then hung the flyers in several places in her high school. He's convicted under a statute which criminally punishes persons with offensive and disorderly acts of language that constitute or annoy persons of the opposite sex. We, that's the appeals court, concluded that the defendant's criminal conviction for this communication did not violate the First Amendment because it was a true threat that had no expressive purpose but was instead intended to get back at the victim by placing her in fear that she might suffer some sexual harm or wind up among the missing. Your Honor can look a long time, I think, at the language of Mr. Kearney's message in an attempt to distinguish it from the Cho case in terms of the language having no expressive purpose, but instead being intended to get back at Lieutenant Tully by placing him in fear that he or his family might suffer some harm. In fact, what other meaning are we to draw from revenge? Revenge. But apart from that, Your Honor, even if there's some far-fetched First Amendment phrase somewhere lurking in this message, the other material is not protected, and the violation of the order does not consist of the language, but simply the content. Now, the other string in my bow, Your Honor, is the argument that this is again a violation of the intimidation of the witness statute. Mr. Kearney and I have gone back and forth on that statute and how it should be construed and how it should not be construed. Your Honor currently has it under advisement. You see my arguments in my memorandum here with respect to this case. I won't belabor them in oral argument. So I will rest at that point.
Okay. Mr. Bradle, tell me about that word revenge and how am I supposed to interpret that?
Judge, this is not a threat. This is not contact. This is satire. This is all protected. I am so sick of having to come before a court because of Norfolk County and talk about speech that Norfolk County
Argue to
doesn't
me,
like.
not to anybody else. Just tell me about that word revenge.
Revenge. Excuse me 1 second.
Yep, no, take your time. You can confer with your client.
Judge, my client is allowed to have hopes and desires and wishes that you or me or Mr. Cosgrove don't agree with their own life or are repelled by. You know, why do we keep having to come back here? I don't know what it must be like to wake up on the wrong side of the First Amendment every day. This is protected speech, Your Honor, over and over again. The Supreme Court has spoken for decades and decades. Brandenburg, Watts, Chaplinsky, O'Brien v. Borowski, Welch. Judge, this is a waste of this court's time. This is intentional infliction of emotional distress on my client. The Commonwealth has been rebuffed over and over and over on this exact scenario. He is not contacting a witness. He is not threatening a witness. He is talking about someone who has destroyed his life, Your Honor. He is allowed to lash out back. And the First Amendment grants every declarant this room to talk without fear, without the kind of fear that this county has inflicted on Mr. Kearney over and over and over again. And it has to stop, Your Honor. This is First Amendment protected speech. I don't care if we don't like it. I don't care. It doesn't matter. He is not threatening Tully. He is not contacting Tully. He is a reporter with his own style of satire that is addressing a large audience, and he is doing a major service pointing out over and over and over again corruption in this county, perversion of the First Amendment, abuse of the witness intimidation statute, Your Honor. This has got to stop. I don't want to come in here anymore and pretend like, gee whiz, this is a close call. It's not, Your Honor. This is First Amendment protected activity that the court, I have every confidence that this court is going to vindicate. This cannot happen over and over again. I get a motion to destroy my client's liberty 3 hours before every single time they want to do this. I get communications, oh, we're not going to try to revoke his bail. Then I go to Stoughton, they want to revoke his bail. What are they doing? They're corroborating the affidavit we talked about 5 minutes ago. where Jennifer McCabe said, I'm not going to
I'm
test.
not interested in that. I'm interested about the word revenge.
Judge, he can say revenge. He hopes it's revenge on a bad guy that's been destroying him. We cannot engage in this kind of content-based viewpoint discrimination. We don't have to like the viewpoint, but like Voltaire's biographer said, we have to defend to the death his right to say it. And that's all this is, Your Honor, over and over again with this. Excuse me 1 second, please, Your Honor.
Yep, no, take your time.
And Judge, in this context, to address your question, in this context, Judge, revenge means karma. He's not saying, I'm going to go get revenge on you. He's saying that karma's a bitch, is what he's saying, Your Honor. And he's allowed to say that. And this isn't something that is intended to be played on a judge's bench in the formality of the courtroom. This is something that he is talking to his viewers online. And he's allowed to do that, Your Honor. So we have got to stop the charade that this is somehow, gee whiz, we got to lock him up because he's talking and satirizing, engaging in political hyperbole, protected by Watts, Brandenburg. The only thing he can't say are true threats and fighting words. We all know that 100 times over. Why are we here, Your Honor? I ask that you deny the motion and just please issue a ruling that settles this issue once and for all, that this has a chilling effect, Your Honor. Every time we're here, how many journalists do we have in this room?
Okay,
You know?
I'm up here. Director remarks to me, not to anybody
No,
else.
I'm just looking to see if there's
No,
journalists, Your Honor.
I'm up here.
There's journalists cover this case. They are experiencing a chilling effect. Am I next? Is the Commonwealth going to go after me next? How far can I go? Can I show up at someone's door and knock on the door? Oh, did I intimidate somebody? Is Norfolk County going to go after me? We don't know. We don't know what they're capable of. And, Your Honor, you're the bulwark here. This is the First Amendment we're talking about. We're kicking this around like it's some city ordinance.
Okay,
Thank you, Your Honor.
all right. I'm going to take it under advisement. Mr. Kearney, please stand up. You're walking on kind of thin ice. I'm going to review everything, and I'll come out with an order. But I take what Mr. Cosgrove has presented very seriously. I also take into account that there are certain First Amendment rights here as well. And then the issue is always, how far does the First Amendment take you, and when does it become intimidation of a witness? The word revenge, some of those other words that are on that tape are getting very, very close. So I'll take it all under advisement. Let me just see the lawyers at sidebar.
Thank you. how far out were you contemplating?
Give me a date, maybe about 5 weeks.
Could I suggest June 8th? June 18th or June 20th?
Is the 20th available?
No, where for you, Mr. Carter?
I'm looking here, June 20th, that's a Friday.
Yeah, that's
Yes, I think Mr. Borrego and I are supposed to be trying a district court case relative to Mr. Kearney on the 9th of June, but it should be concluded by
Yeah, I would think
the
that.
20th.
Yeah.
So that's fine. 2 o'clock or?
Okay, the 20th. Thank you. I'll see you all then.
Thank you, Your Honor.
May I try your patience?
Try my patience. You answer right now. Go right ahead.
Which is that, like Mr. Borrego, I am very tired of coming back here with these motions.
I'm sure you take your,
I honestly think that if the court does not act to protect the witnesses, we'll be back in front of you very soon because he doesn't stop.
Okay. Mr. Brado, I'll give you a short response.
Yeah.
I'll give you 30
No,
seconds.
Judge, it's protected activity. That's all there is to it.
Okay.
Thank you.
Thank you. All right.
Thank you.